everyone, today we will be talking about patent. So today in my video we will discuss about introduction to patent. What is a patent? So patent means a patent that is granted for any invention under the Patent Act. Section 2 subclause M of the Patent Act defines patent in this manner. So patent comes under the intellectual property right, meaning anything which one has created by using their intellect, their mind. Now, when it comes to patent, what is necessary and why patent is granted? So basically, patent is an exclusive right which is granted to a person who has invented a new and useful article. It consists of an exclusive right to manufacture or use the new article invented for a limited period of time. And after the expiry of that period, anybody can use that particular invention. So, exclusive right is basically the right to exclude others from using or manufacturing that particular article in unauthorized way. So patent is very useful, and when one is granted the patent, it is done to acknowledge the fact that that particular article or process has been created by this person. So it is done to encourage that person, it is done to acknowledge the fact that it has been created by so and so. Now, when it comes to the definition of the Patent Act, which has been provided to us under Section 2 subclause M, which states that patent means a patent for any invention granted under the Patent Act. So, what do we understand by invention? It is clearly specified that only inventions will be granted patent. According to a layman, invention is when someone is creating something new. You are inventing something new which was not known earlier. Now, here under the Patent Act, invention means a new product or process involving an inventive step which is capable of industrial application. So, anything which is new, which is novel, which involves an inventive step. Inventive step means anything which is non-obvious, meaning anything which was not known before, which was not in the public domain before this particular article. So anything which is new, anything which is non-obvious and which has some utility, meaning which has some industrial application. So when all these three things are there in a particular article, then it will be considered that it is an invention. So for invention, there should be something new, anything which was not known before, which was not present in the public domain, and which has some utility. So this patent is granted with the objective to gain commercial advantage to the person who has created it. So by giving the patent, by granting patent, people are getting encouragement that we should make something new, we should develop something new. And if we do that, then we will be granted this exclusive right of patent. And obviously, it is granted to encourage scientific research, new technology, industrial progress. So all these are the objectives. By keeping these objectives in mind, patent is granted to people. Now, there are two kinds of patent. One is process patent and the second one is product patent. When we talk about process patent, in that case, patent is granted for a particular process. Generally, process patents are found in cases of medical, in the field of medical or in the field of food industry. So for making any particular thing, for making any particular food item or for making any medicine, if there is any process that is involved in that, okay, which is a new process which was not known before, in that case, for that particular process, patent can be granted. And in the case of product patent, obviously a new article is made. Okay, there is some new article, there is something new which was not there, which was not present earlier in the public domain, which was not at all. So this is what we can say for what things, how, what are the characteristics, what are the essentials which one should have to get the patent. But there are number of inventions which are not patentable, though they are inventions but are not patentable. And these non-patentable inventions are given under sections 3 and 4 of the Patent Act. So anything which is frivolous or claiming anything obviously or contrary to well-established natural laws are non-patentable. Or anything which is contrary to law or morality or injurious to public health is not patentable. And obviously, when it comes to invention, discovery and invention are totally different things. Invention is when you're creating something new, and discovery is when you find something which was already existing in the nature. It was already there, it was already present, but you discovered it. So, if there is just a mere discovery of any new form or new use of a known substance, then it would not amount to patent. Or if you are mixing two things, so mere admixture resulting only in aggregation of substances, or mere arrangement or rearrangement or duplication of known devices won't lead to grant of patent. Or if there is any method of agriculture, horticulture, process of medical, surgical, curative, diagnostic, therapeutic, or other treatment of human beings or animals, or if there are plants and animals in whole or in part, including seeds, varieties other than microorganisms, then all these things won't be granted patent. And when we talk about any mathematical or business method or computer program and algorithms, these won't come under patent. Or we can say that any literary, dramatic, musical, or artistic work, sound recording, or cinematographic films, for all these patent is not granted. When it comes to any literary work, dramatic work, or cinematographic films, so in such cases, copyright is granted. Okay, because these are the things, music is already there in the environment. It's not an invention, it is already present, it is an art, and for this copyright is granted, which is one kind of intellectual property right. And if you talk about any scheme or method of performing any mental act or game, or if you have come up with any new rules in a game, then no patent will be granted for making some new scheme or coming up with new rules in a game, then patent won't be granted. Or if there is any presentation of information or topography of integrated certificates, so all these things won't be granted patent. And of course, one more important thing, that an invention which in fact is a traditional knowledge or duplication of known properties of traditionally known components will not amount to patent, because the knowledge was already there. Okay, you just found out right now, then it won't amount to patent. Okay, so anything where you are using your traditional knowledge would not amount to patent. And any invention relating to atomic energy will not be patented. So it is an invention, though some new thing has been invented, but still, if that involves usage of anything relating to atomic energy, anything relating to atomic energy is defined under section 20 subclause 2 of the Atomic Energy Act. So anything which falls under that category will not be patented. So this was in short about what is patent and what cannot be patented. I hope this video was helpful to all of you. Please do like, share, and subscribe to my channel. And for subscribing, you can press the bell icon that is given below my video. So please do subscribe to my video. And in case you have any query in regard to legal matters or law exams, you can reach out to me on my email ID or on my Instagram ID. Link for the same is provided in the description below. Thank you very much.